Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer. I want to talk to you today about buyers recovering their earnest money based on the financing contingency in a situation where buyer's lender is incompetent. Here's a scenario. Buyer was pre-approved, or let me back up. Buyer had a pre-approval letter at the time of mutual acceptance. But within that 5-day period after mutual acceptance, buyer decided to go with a different lender than they had gained pre-approval from. They went and they made their loan application, or they thought they made a loan application, I should say. The lender asked for, the normal stuff, W-2s, their tax returns perhaps, whatever the documentation is that you would expect a lender to ask for when the lender is making a loan application on behalf of a potential buyer. And buyer leaves this meeting believing that they've done what they need to do as far as making loan application within 5 days. Time goes by. There are a few red flags that come up for the buyer and the buyer's broker. Phone calls don't get returned by the lender when they should. Emails don't get returned. But eventually, the lender says, I'm submitting your loan right now for underwriting approval. Yay, buyer broker thinks, well, this lender hasn't gotten back to my emails, but if they're ready to go to underwriting, so be it. That's great. And then the next communication is, sorry, buyer, you can't get financing. Fast forward to the point where buyer broker asks for the letter of declination, the lender letter that's required by paragraph 5 of Form 22A in order for a buyer to recover their earnest money. And lender says something to the effect of, I can't give you a letter of declination. Your loan was never declined because you never made a formal loan application. I was just poking around with different lenders to see if I could get financing for you somewhere, and it turns out I can't. So I can't give you the letter you want. The question that comes to me as the hotline lawyer is, shouldn't buyer recover their earnest money anyway because buyer did everything that they could do? They made a good faith effort to make loan application. It just turns out that this lender was incompetent. And unfortunately, the answer under the statewide forms is very clear. The answer is no. In order for buyer to terminate the purchase and sale agreement based on the financing contingency, Form 22A, buyer has to make loan application within 5 days of mutual acceptance. When a buyer makes loan application, formally makes loan application, the lender is required to respond by providing buyer with what's called a loan estimate. It is a standardized document that has to include certain information, and the lender must deliver this document to buyer. Form 22A, the financing contingency, goes on to say in paragraph 5 that before a buyer can recover earnest money based on a financing contingency, the buyer must provide to the seller a letter from buyer's lender showing that buyer made timely loan application, and the lender's statement that buyer made timely loan application must be supported by a copy of the loan estimate that lender is required to give to buyer. Then the letter has to go on and describe that buyer had sufficient funds to close the transaction and the reason that the funds were not available. But in this question that we're talking about today, we never get past those first two requirements, that buyer made loan application within 5 days following mutual acceptance, and that the copy of the buyer's loan estimate provided by the lender at the time of loan application or within a couple of days after loan application is attached to the lender's letter. This is not a matter of good faith. It's not a matter of we feel sorry for the buyer. The buyer did what they thought they could do. The fact is, buyer hired an incompetent lender, and now buyer bears the brunt of the cost of this failed transaction through the forfeiture of buyer's earnest money. This is a sad story. So why am I telling you this sad story on a Friday video? Because brokers, you can prevent this outcome. Well, maybe I shouldn't say that. You can go a long way towards preventing this outcome. There are some buyers who certainly are stubborn and they're going to hire the lender they want to hire no matter what. But in that case, I hope you have documented your transaction file with evidence of the fact that you have communicated to the buyer that the buyer needs to hire a competent lender. Here are 3 lenders, here are 5 lenders, here are 10 lenders who I know to be competent. I strongly encourage you to use one of these lenders to make loan application. Listing brokers, educate your seller about the need for sellers to require that the buyer who has a financing contingency hires a competent lender. Who is the lender who wrote the buyer's pre-approval letter? Is it a competent lender? If it is, then in the purchase and sale agreement, consider requiring the buyer to actually obtain their loan from that lender who wrote the pre-approval letter. Then we know that buyer's got a competent lender, and it's a lender of buyer's choosing in that way. Part of the problem in this story arose from the fact that buyer and buyer broker worked together for buyer to get their pre-approval letter from a certain lender, and then buyer went out and made loan application with a different lender. Remember that in this situation where buyer's going to forfeit their earnest money, it's because there are 2 parties in this transaction. There's a buyer who's going to lose out in this case, and there's a seller who's also going to lose out if buyer gets to keep the earnest money. It's not seller's fault that buyer hired an incompetent lender. So if we feel badly for buyer, who's going to forfeit the earnest money in this case, remember that there's also a seller in this transaction who's being damaged by the loss of the sale after having had the house off the market for however many weeks or months. And so the financing contingency says, buyer, you only get your earnest money back if you satisfy the requirements of paragraph 5. And one of those requirements is that you actually made loan application within 5 days following mutual acceptance. And in this case, that meant buyer, you had to hire a competent lender. These are bold facts that illustrate the importance of having a competent lender. The facts might not always be so obvious, but the outcome will always be the same. It works to both buyers and sellers' advantage. And of course, if it works to buyer and seller's advantage, who else does it advantage? It advantages the brokers who are getting compensation from a closed transaction. It advantages everybody involved for buyers to hire competent lenders. Brokers, make sure you have that conversation with your client, whether your client is the buyer or the seller. And if you want to have more conversation about this with me, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.